Just so you know, we spent a lot of time discussing the issues that Bob had discussed and Sheldon and others asked questions about. And Bob Conklin and Bob Lardo were instrumental with respect to working through those issues, and we'll continue to work through those issues to the extent they pose any issues. I was in your shoes for a number of years, so I certainly understand some of the issues you may have. At this point in the program, Betsy Sterling and I are going to discuss an overview of the type of litigation we see in federal court from pro se litigants, meaning non-prisoner pro se litigants. We obviously have a tremendous caseload of prisoner cases, but this program won't have anything to do with that because there's really no way to get the prisoners there to meet with you. Although Betsy and I would certainly welcome any assistance that the prisoners could get in directing their complaints. And I know a number of the attorneys in the room have in the past represented pro se litigants and prisoners. I know one won an award last year for that. And whenever you can volunteer to represent a pro se litigant, either a non-prisoner or a prisoner, meaning when I call you and start begging, please say yes. Jeremy did one not too long ago, and it took him about 4 minutes, and the case was resolved. Doesn't always work that neatly, but sometimes it does. So a lot of times I may call the more senior partners like you folks, and I'm really calling to get someone younger than you or less experienced than you involved, unless it's a case where I think we need the type of experience that's in this room. You know, mentoring is such a huge part of a young attorney's legal career, and whenever we can do that, I think we should all try to do that. So Betsy, we're lucky to have Betsy. She's been with us 4 or 5 years now. She has spent her whole life in legal services. Prior to coming to the court, she spent about 15 years with prisoner legal services. So Betsy is extremely well-versed and well-experienced in dealing with pro se litigants. And she's going to speak about how the court deals with a lot of the issues we see in this court. I'll later discuss some of the actual substantive issues we see, and I apologize if the outline's a little too basic. I didn't know the exact audience before I prepared it, and I looked at it yesterday and I'm thinking, oh, Monell liability for counties. I'm thinking Paul can certainly teach me everything I need to know about that. So to the extent what I may discuss is repetitive for any of you, I apologize, but it will be excellent for the students who will see these issues as they meet with the litigants. So Betsy's going to start, and then we're going to tag team this.
Hi, everyone. It's great to see all of you here. I'm really overwhelmed by the level of experience in this room. This is a project that's near and dear to my heart. I came from legal services after 25 years there, and I was astounded by the number of pro se litigants in this court and the limits of what we could do for them. And for Chuck and I, and we have 2 other people and 2 other attorneys in the pro se department, it's a very difficult line for us to walk. Clients come in, plaintiffs come in, they arrive at the clerk's office, they ask for forms to fill out to file complaints, they're given complaint forms. If they have questions, the clerk's office does the best they can in terms of handing them forms or sending them to other referral agencies, of which there are very few, but that's the limit of what the clerk's office can do for pro se litigants. Eventually, people end up with people like Chuck and I. They think they've gotten somewhere. They hear we're attorneys, we work with pro se litigants. They say, oh, I'm so happy to see you. Can you answer my questions? And our first response is, not really. All we can really help people with are procedural aspects of their cases. So we can tell them things like, when you're served with a scheduling order, what does that mean? You read the order, you look at the deadlines, this is what the court's requesting that you do for them. We cannot answer substantive legal questions for people, which is very, very difficult. And so to have a clinic like this coming to the federal court is enormous. People are very receptive to having attorneys sit down with them. I strongly believe even with limited scope representation, plaintiffs will be enormously satisfied because they're able to come back to the clinic again. It happens with work we do at various stages in the case. They'll call us up again. You know, they get another order from the court and they say, okay, Betsy, I got another order. What does this mean? I read it through with them. I try to direct them. They can do the same thing with the walk-in clinic or by scheduling an appointment. And my experience with legal services is this, that clients listen to what lawyers tell them. Even if a lawyer is saying to them, I don't think this claim has merit, or, you know, you've listed 10 claims for me and I really only think 2 do. Clients listen to that. And this, you know, reputation that sometimes pro se litigants have is a lot borne by the fact that they don't have a lawyer that they can consult with. They have no one that they can speak to. This issue comes up a lot in the court because when we do appoint pro bono counsel, often the case is very far down the road. And so sometimes those of you who are called to take on a pro bono case, you know, look at this mammoth complaint and think, what am I going to do with this? This case has been pending for 2 or 3 years. But that's the result of no one meeting with the client early on and narrowing down the claims. There's an agency out in California, what do they call the Public Law Council. They call themselves the biggest pro bono firm in the nation. They have, you know, 60 attorneys on staff, 50 support staff, and they run pro bono projects, and including a federal court clinic like this. And what they say about their clinic that they run is that 85% of the people that are advised claims don't have merit accept that advice and do not bring those claims. So what that means is what then ends up in the court, either by cases or claims, is of much higher value and of much higher merit. And the court can then focus on what's really relevant to the client. So I can't say enough about the value that I believe this clinic will add to clients' cases and also to what the court's able to do with it. But I wanted to talk a little about the types of issues that clients are going to come in asking questions about. One thing is initially when they file their claim, they either need to pay the filing fee or file an informa pauperis application. And the filing fee in the court, it's $350 plus there's a $50 administrative fee. So it's a very high fee for an indigent person or someone of moderate income. The court can waive the filing fee by granting an informa pauperis application. And the clerk's office has a form application for clients to complete. One of the biggest problems people like Chuck and I have in reviewing those is the forms are not completed. So we can't tell if it's just somebody that, you know, is having a difficulty with our form itself or is somehow withholding information that maybe would not make them income eligible. So that's something to just, you know, look at if you're assisting someone with an IFP application to make sure they complete the form. You know, generally, someone who is receiving any kind of income-based state or federal subsidy like food stamps or SSI benefits, public assistance, will qualify for IFP status with the court. You know, the standard is relatively based on the federal poverty guidelines, which is similar to what legal services programs use. The goal is, you know, if someone would have to give up food or housing or something else to come up with the filing fee, they need to be granted IFP status. And that's the way the court reviews those applications. What IFP status gets a litigant in this court is the ability to file the case without paying a fee and service of all documents by the U.S. Marshal. It does not give a litigant access to deposition costs or access to any other costs that might be incurred during litigation, including experts, which is obviously a problem because if a litigant can't afford to take a deposition, which they're not going to be able to if they have IFP status, their questions will then become, how do I get the information I need? And they'll appear again at the clinic, I would expect. Once they get a notice that they're being deposed, they'll say, what is this? You know, how come they can take my deposition? How can I take their deposition? So another, I think, area in which the clinic can really help is to advise people about no-cost or low-cost discovery methods. Things like how to how to serve interrogatories, how to serve requests for production. Other mechanisms, there may be questions about whether they can subpoena certain documents. It takes a lot of creative thinking to work with a pro se litigant to help them get what they need. For those of you who have taken on pro bono cases with the court does have a district court fund that if you're a pro bono attorney and need money for litigation expenses, to hire experts or to take depositions, you can request that from the court. I think people who have utilized that probably realize it's not a lot of money. I think the cap is $1,800, which obviously if you're hiring an expert, it doesn't go very far. But for a pro se litigant without an attorney, there's nothing available for them in terms of the funding. Once they're granted informa pauperis status, it also allows them to request appointment of counsel, which would end up, if anything, being pro bono counsel. From Chuck and my perspective, the requests that plaintiffs file for appointment of counsel are often incomplete or premature, which really doesn't allow the court to grant them counsel. For example, sometimes when people file their lawsuits along with the initial complaint, they'll file a request for appointment of counsel. But there's not enough information before the court for them to make that sort of assessment. And the criteria that the court really looks at is whether or not there's a likelihood of merit to the claim and whether or not the individual's circumstances make it such that they need counsel. For example, do they have difficulty with the English language? Are their abilities just so short of what would be required for them to pursue their case? So when plaintiffs file those requests too early on, it's very common for them to be denied by the court as premature, told that they have to wait for issue to be joined, lay out the standards for them. So I would suggest that if people come to the clinic and you think it would be appropriate at whatever juncture for them to be filing a request for appointment of counsel, which we also have a form pleading for, if you think very carefully about the criteria the court needs in order to grant counsel and make sure that's in the document, because clients tend not to put that level of information. I mean, I think what we end up seeing a lot is either way too much information or way little information. And there's sort of, this middle ground of what's appropriate to put forth before the court and what we need to do to be able to do our jobs. I'm not going to go through the documents themselves with you, but our website and the links were in the materials to that. On the court's web,
They can see the guys if they want to do one card. Or so Lisa can jiggle it.
Just hit the space button.
I can do that. Well, not really. Okay. Feel free. It would be out. I was trying to.
Do you want to go to
Thank you. If you could, representing yourself. This is the tab and everything. This is our homepage, and under this tab are a series of forms that the court has that really lay out the format for plaintiffs to use for filing documents. Questions that clients have tend to come timed with orders that they received. For example, if a Rule 16 scheduling conference is ordered, they'll always call and say, what does that mean? And clients, I think if there's one general rule, it's that pro se litigants do not understand the course of how a case progresses in the federal court. They really, they know they come to court, they know they filed a complaint, but they can't really figure out what the steps are after that. So a lot of times, they'll ask questions about that, and they'll be confused as to how much they need to produce as the case goes on. So for example, we have some plaintiffs that just keep filing document after document after document with the court. This happens a lot, particularly in prisoner cases, just like random documents that for them are related to the case. You know, it's their proof, it's their evidence, it's their exhibits. And they have a hard concept of understanding now's not the time to produce that. You know, there'll come a point in the case in which they need to do that. So I think a lot of the assistance you can provide is just to explain like the course of how litigation works in the court. The other thing to
Just a question.
Sorry, yes.
In all of this, what's the role of the students and what's the role of the mentor attorney in this process that you're laying out? And how much, when we get involved as taking over something from the students, or where would we say, let the students take it and run with it at least until they get out of breath?
I'm going to punt that to Bernadette.
Due to the nature of a practicum and the fact that it's not a clinic and there are not practice orders with the students, the way the center will actually be set up is the students will be there before the attorneys. They'll be familiar with all the forms that Bob was talking about, the intake forms. They'll have met with the client, so they'll have done an initial intake and interview of the client. That'll be all ready for you when you show up. So they'll have the initial contact with the client. When the attorney gets there, what we're hoping is that we have at least 2 students for every session, and right now that's the way it is, 2 to 3 students. So one student can accompany the attorney into the client advice room. So we want the students to come along with you. At that point, the attorney really has to be giving the advice, not the student. They're not in practice yet, and this is not a clinic with practice orders. So that's how the students will get involved. In addition, right, we'll have the continuing research and review that the students will be doing, but in the actual day-to-day with the attorneys, that's how the students will function.
And the students will get familiar with the resources that are there, the court forms that are there, the referral information that's there, the memos that have been prepared, so that they can say, you've got this, you can talk to them about.
The students will actually be creating many of those materials to be reviewed, obviously. But they'll actually be creating that. So many of the resources they'll be able to point to for the litigants, but not actual advice. Okay?
This is a manual, I think the link was in the materials, that's been created by the court that is a really useful manual that is handed out to pro se litigants when they file their cases. And it tries to take them through procedurally the case. So there's information in there on the discovery process, how to serve papers, how to file a motion. It's a sizable manual, but it's not substantive, you know, in terms of the law. And it's a lot of what we tell litigants because it sets out process for them. But the gap for them is they can't figure out how to put the legal substance into it. And I think that's a large part of where you all come in, is trying to tie up the procedure with the substantive case that they're here for. Something I do want to mention, because it's unique to pro se cases in the court, that all discovery does have to be filed with the court. And I know in other cases it isn't. So sometimes when people are handling pro se cases, they forget they need to file it with the court, but both parties do need to file. I'm short on time, sorry. I wanted to mention also that pro se cases are subject to the court's alternative dispute resolution process. So most cases, when they come in, we'll get a notice of ADR referral. Maybe the one thing to keep in mind about these cases is that there's a fee for using the mediation services of the court. If someone's been granted IFP status, their share of the mediation costs are just automatically waived. If someone has not been granted IFP status, but still cannot afford the services of the mediator, they can file a petition to have their share of the costs waived. And people that are mediators for the court do pro bono work for the court on indigent parties, and that's how we're able to waive the fees. Another common area that plaintiffs have a lot of questions about are default judgments. A number of plaintiffs may bring lawsuits, not against large defendants, but individuals. And often the individuals, or on occasion the individuals, never appear, they never respond to service, and the plaintiff will be calling the court saying, can I, haven't I won? Can I get a default? And the concept is difficult for litigants in understanding. They have to do two things. One is, if the other party hasn't appeared, they have to first get the entry of default from the clerk's office, which is more or less a ministerial act. They can make the request to the clerk's office in the form of a motion with an attached declaration saying, I served my papers on such and such a date, here's the affidavit of service, but there's been no response. That allows the clerk to issue the entry of default. And when that happens, plaintiffs tend to think the case is over and they should get whatever it was they requested. But in the federal court, there's step 2, which is they have to file a motion to request a default judgment. And that then allows the court to assess the damage aspect of the claim. If their papers are very clear and it's a precise number, it's possible that could be entered without a hearing, although I think it's probably not that common that would happen. The court would have to hold a hearing for the default judgment. And that's a piece that plaintiffs don't seem to understand. They think it's a one-part process and don't understand why they're not getting a judgment. So there's a lot of questions around that. The forms that the court has includes all the way to filing an appeal of the case. So I think the first step often when someone walks in is to just take a look at the forms and see if there's something there that you can use to assist them with whatever step of the process they're in. And then the final thing I'm just going to say before I hand it over to Chuck is plaintiffs don't really know where they can access the law if they want to attempt to do their own research. A lot of them don't have access to computers, and they're looking to go sit in the library and actually open up books and look at hard copies. So that they can be referred to the court library, they can be referred to the state court law library, and I don't know if the law school library is available to them also. Thank you. Any questions? Hand it over.
Thanks, Betsy. 10 minutes is about enough time to cover all the substantive areas you may see. Again, one of the ways Jody reached out to all of you was to try to have some of the more experienced litigators in Buffalo to sign up and volunteer for the program, and that worked. Thanks, Jody, for that, because especially initially in the program, it's going to be important to have very experienced litigators who can handle maybe any type of litigant or any type of claim. Before I get into some of the substantive areas, there are a couple things I just wanted to mention that I've been hearing throughout the course of the day. I hope and expect that a lot of the litigants who come to the clinic will already have cases pending and will have questions primarily about discovery. How do I oppose a motion to dismiss? How do I oppose a motion for summary judgment? And we're going to speak with court personnel later on to tell them, refer these litigants to the clinic. Don't have them call me. Because like Betsy said, they often call, oh, are you an attorney? Yes. And that's when my antenna go up, and I have to tell them, I can't represent you, I can't give you legal advice. But we are going to encourage the court staff, especially the law clerks, to have the litigants sign up, or if they're on a Wednesday or Friday at a court conference, to come down and meet with a student and an attorney. So we hope that a lot of the questions will be not just how do I file my lawsuit, but how do I respond to a deposition, how do I request documents, how do I file interrogatories, etc. No one's asked or told you where the clinic is. It's right next to the clerk's office. So you go into the clerk's office, and there's a conference room right off the clerk's office which will be set up with desks and 2 partitions. So it's a really nice room, you'll be comfortable. Make sure if you're the attorney, you have your PED photo ID card, so you can bring in your electronic devices. In the event no one shows up that day, you can do some work while you're there. Volume, we just don't know. This week I probably met with 4 litigants. I was hoping it was next month, but it was this week. And they had some really good questions, and unfortunately I was only able to help them so much. But if that happens, when I meet with them, I will refer them to the clinic. I just don't know how many people on any given day you will see. Betsy mentioned that all discovery must be filed. And I know, especially in employment litigation cases, this becomes a problem because 5.2 of the Federal Rules of Civil Procedure require redaction of confidential material. The pro se litigant has no idea about that rule. We provide them a privacy notice, it still doesn't matter. So if someone comes to you with discovery questions, make sure they redact the confidential information from the documents they have to file with the court. The clerk's office can't do it, I can't do it. Make sure they try to do it themselves. Service of the summons complaint. If they're informa pauperis, the marshal does that. They have to complete the marshal form and the summons form, which they will get from the clerk's office. So explain to them how service is done. It's done by the marshal service through CPLR 312-A, which is acknowledgement of service by mail. Take them through the process. Service is not complete until the acknowledgement is returned. If the acknowledgement is returned within 30 days, they have to request the court to serve it again. The marshal is not going to follow up on service. If the acknowledgement doesn't come back, there's no service. So the litigant has to be aware that he or she has 120 days from granting of the IFP application to make sure service is effective. If you get a litigant that wants to pay the fee and you can't talk them out of it, they can do that. They'll be responsible for service at that point unless they file a motion for service by the United States Marshal, which the court, in its discretion, can grant. So those are just a couple of things I wanted to point out that may come up often when you meet with the litigants. Case assignment is just like in a non-pro se case. It gets assigned randomly to a district judge, and once issue is joined, it will be referred to a magistrate judge. Explain the difference between consent and referral. A litigant, when the case is filed, will receive from the clerk's office through the mail notice of availability of a magistrate judge. They're going to have questions about that. I get questions all the time about what that means. Oh, well, I didn't sign the referral order. Why was this matter referred? All cases get referred. So you may get questions about the difference between consent and referral. Probably the most common type of case we see on the non-pro se prisoner side are employment discrimination cases. Especially since the recession in 2008, we've seen a tremendous increase in pro se employment discrimination and Social Security cases. However, Social Security cases are now usually attorney represented. We've seen Ken Hiller signs. He files a lot of cases, which makes it a lot easier for the court. And for the litigant, obviously, they have an attorney handling their Social Security cases. Anyone who's litigated employment discrimination cases in the past knows there are administrative prerequisites that the litigant must comply with. Make sure the litigant, before he or she comes, has the right to sue notice. Because we have to know when we review the complaint whether or not the complaint was brought within 90 days of receipt of the right to sue notice. Another issue, and we have a separate employment discrimination form. I'm not going to play with this. That lists the 3 federal statutes you can sue under. Title VII, ADA, which is usually a Title I issue, or the ADEA. We also have a spot on the form where the plaintiff can elect to also bring a state law, executive law, division of rights claim. There's obviously a lot of confusion between the Title VII and the DHR claim. They may have questions about what that means. Try to be able to answer that question as best you can. And they can have a pendent state law claim if they check that box. Defendants in an employment discrimination claim. Title VII, all the federal statutes, you can only sue the employer, you can't sue the individual. Under state law, in very limited circumstances, as you know, you can sue the individual if the individual did more than carry out the orders of another. So basically, are they an owner, and were they the one who actually carried out the personnel decision? You may be able to sue that individual under state law, not under federal law. Those are the common questions you get in employment discrimination. The next area we see a lot is obviously civil rights. Everybody has civil rights, no one knows what they mean. Obviously, private individuals can generally, unless they're conspiring, violate an individual's civil rights because they're not a state actor. 42 U.S.C. 1983, everyone knows that's how you can sue a person acting under color of state law for an alleged violation of your constitutional rights. We get a lot of questions from individuals about how do I sue my neighbor? How do I sue the person who foreclosed on my house, etc. Those generally aren't actionable in federal court because there is no state actor who allegedly violated your civil rights. When they talk about civil rights, ask them what they're actually complaining about. Because everyone, like I said, thinks they have all these civil rights but really don't know what that means. Try to clarify with them what they claim happened to them and who did it. If it's a person acting under a color of state law, a police officer, a town clerk, those are people acting under color of state law that can be sued for a violation of the individual's constitutional rights. Those are some of the common issues we see all the time. They sue the wrong individual. They sue the wrong entity. They sue the state. Students, the state can't be sued under 1983. They have 11th Amendment immunity. Municipalities, counties, cities, towns, they are persons acting under color of state law, but unless the constitutional violation occurred pursuant to a policy or custom of the town, of the city, of the county, they can't be sued. So if they insist on suing a county or a municipality, they have to allege that there was a policy or custom that led to the violation of the constitutional rights. There's a federal counterpart to 1983. It's called Bivens. The Supreme Court created a cause of action for a violation of a constitutional right committed by a person acting under federal law, an FBI agent, someone at DHS, someone at the border. Those individuals can be sued as federal employees under Bivens. All the 1983 law generally applies to Bivens actions. So be aware of that if someone alleges their rights were violated by a federal employee, not a state employee. They also sue often under 1985 and 1986. I'm not going to go through all that. It's in the outline. I'm running out of time. So look at the difference between 1985 and 1983. You'll understand it. One thing to keep in mind is, unlike state tort law, there is no respondeat superior in 1983 actions, meaning you can't sue the employer for the acts of the employee. The person you sue must have had personal involvement in the alleged constitutional violation. There's been a lot of case law since Iqbal about what is or is not personal involvement in the alleged constitutional actions. That case law is far too numerous and at this point still unsettled in the Second Circuit, so I can't go into that. Another area, you may see some false arrests, some malicious prosecution claims, again, suable under 1983 and state law. State law federal law are the same on the elements of false arrest and malicious prosecution. Be aware of that. 2 cases to be keenly aware of with respect to the false arrest, malicious prosecution area, and which are very, very confusing. One is the favorable termination or delayed accrual rule of Heck versus Humphrey, and the gloss put on that by Wallace versus Cato. A very difficult area. You may get some questions about that. If you do, those are the 2 cases you'll want to read and be familiar with. Very briefly, if an individual has been convicted and they seek to sue the police officer for false arrest or malicious prosecution, they cannot sue under Heck unless that conviction has been invalidated by either a state court on a 440 motion, the appellate court, or even federal court in a habeas corpus petition. Until that conviction has been overturned, they have no claim for malicious prosecution, for a due process violation, for a Brady violation. There's many exceptions to all that, but be aware of that. The biggest exception lately is the case of Wallace versus Cato. Before Wallace, if someone had a false arrest claim, we would just go to Heck and say, you can't sue until your conviction has been invalidated. It's a delayed accrual. But a few years ago, the Supreme Court said, no, false arrests accrues as soon as the individual is arraigned. At that point, they're no longer falsely arrested. They are subject to the legal process of the court. So a false arrest accrues at the time of arraignment. So although their conviction hasn't, they eventually convicted, they sue within 3 years, they still don't have a claim because the conviction has not been invalidated. What's the court to do? The court will stay that false arrest claim until and if the conviction is overturned. If the conviction is overturned, the litigant is supposed to come back to the court, tell the court, my conviction has been overturned, let's lift the stay and we'll move on. While the court stays actions, very rarely does the litigant come back with an invalidated conviction. So then they're convicted, the case is barred by Heck. If anyone understands that, come talk to me. Another area you're going to see a lot of maybe, again, Ken Hiller has done a lot of work in this area, and I'm not picking on Ken, he does a lot of work in this case, in this court, is fair debt collection practices. There are a number of those cases. Familiarize yourself with